Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada but Didn't. Today we're talking about nuisances. Cases that should have gone to the Supreme Court of Canada but didn't. Under Canadian law, it's possible to sue your neighbour or another individual if they cause you a nuisance. This often comes up in situations where there is construction that's causing disturbances of individuals in a community or other noise violations, things like that. In the case of Jean Rivard, he brought a lawsuit against a maple syrup farm that was being constructed in his neighbourhood. He had originally been opposed to the construction of the farm and opposed to the permits being granted during the development hearings at the city. And ultimately, in the civil trial, his opposition was used as a factor by the trial judge to find against him. The trial judge determined that in part because he was in opposition to the construction, that motivated him to bring the civil claim in order to achieve the result that he didn't achieve by expressing his opposition to City Hall. And this case raises very important issues about the use of information in proceedings where the public is invited to weigh in on issues that may affect them in order to negatively impact somebody's credibility in a later trial where they are arguing that they have been affected in the way that they were worried that they would be. It raises important issues about how valuable the public process is and what protections people should have in a public consultation process where they're invited to express their views and where their views should be taken into account by the city. It produces a chilling effect on people participating in these public processes to know that if there is a problem and they later bring a lawsuit as a result, that their opposition in the public process could be used against them, or alternatively, that their willingness to allow the project to go ahead in the public process may also be used to undermine them. Ultimately, these processes should be protected and should have some sort of a degree of recognition of protection against use by an individual later against a person in a trial, because nobody is contemplating dealing with a trial usually at the time that they're participating in these processes. It's unfortunate that the Supreme Court of Canada didn't recognize the potential chilling effect this could have on public consultations in an age of significant construction. Unfortunately, we'll see more cases go to the Supreme Court of Canada where these issues likely will not be considered before we finally have an answer as to whether there should be some protections for public consultation process statements that have been made by individuals. Cases that should have gone to the Supreme Court of Canada but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada but Didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.